logical, and rational. The city attorney has given me all the introduction I need. My name is Gabe Ross, so I'm with the law firm Schutmahalle and Weinberger up in San Francisco. I've been working with Hills for Everyone and with the Appellant on this project for what seems like a long time to me, given what's gone on in my life. I was looking back at the date of the first letter I wrote. Since the day I wrote the letter, I've gotten married, I bought a house, I was made a partner at a law firm, and I had a baby who turned 2 last week. But with all that behind me, this project has been going on for much longer than that. So I'm a rookie here compared to the people who just spoke. I travel all around the state, and I work on both sides of this podium. I represent community groups like the Appellant, and I sit where the attorney sits in other cities. And I want to say that I've never been as proud to be a part of a team as I am now with this presentation that came before me. It made my job so easy, because what they've done is explain to you all of the real reasons why this project shouldn't be approved. They've taken this out of the hands of the lawyers and explained what's really going on here. I have to, for a moment, take it back into the hands of the lawyers. But what I'm really here to talk about is about the city council, not about arguments between lawyers or agreements between lawyers, but what you should do and can do with this project, because you have the authority over this project. It's the city council that decides if the benefits of the project outweigh the damage to the environment. The state law says that the project must be consistent with the general plan and with the Carbon Canyon specific plan, but it's this city council that decides whether to overlook certain inconsistencies that have been identified. The lawyers have disagreements over the application of the hillside management ordinance and what sort of evidence should apply when you're deciding how it should apply, but ultimately it's this city's ordinance and it's this city council's decision to find the most reasonable reading of that ordinance. All of these decisions are yours. Now, you've heard about how a court might view these. You've heard about how the applicant might view your decisions. And the proposal, I think, is that a court would look kindly upon your decision to approve this project. Now, I agree with that position, but ultimately those are lawyers' points. And what we're asking you to do, for all of the reasons that the team has just supplied you with, we're asking you to not think like lawyers, but to think like the people's representatives. Not to consider what you might get away with, but to consider what makes sense for this city and the people who live here, and the people who will live here. I'm going to take the points where I believe that you have clear authority one by one, and briefly explain why I think this is your decision and no one else's. First, you clearly have authority to say no to this project. As I mentioned, state law, and as you know, of course, state law requires that a project like this be consistent with the general plan and with the Carbon Canyon specific plan. The EIR before you says that it is not. It admits that it's inconsistent. It's clearly your decision to decide that that inconsistency is too much and this project can't be approved in the city. CEQA, the Environmental Review Law, says that when a project has significant and unavoidable impacts, as this one does, the EIR says it has 3 of them, then you can only approve the project if you decide that the benefits outweigh those significant unavoidable impacts. That weighing is yours. I think, given what the team has shown you, that conclusion is clear, but that weighing is yours. No one can take that away from you. A settlement agreement that purported to take that away from you could never do that. It's been suggested that there's exemptions from this requirement. Again, this is a lawyer's dispute that will be worked out on paper, but I would make the clear point to you that if there is such an exemption, it would only apply if this project was consistent with the Carbon Canyon specific plan, which there is no doubt that it isn't. The EIR says that this project is inconsistent. No exemption can apply. The decision to weigh the benefits against the environmental impacts is with the five of you. The second place where you have authority is in interpreting the hillside management ordinance. The arguments there have been laid out clearly. It never says that it's limited to any particular area. It clearly, as Bev said at the beginning, applies to the entire city. Moreover, there's no conflict between the hillside management ordinance and the Carbon Canyon specific plan. They clearly can work together. The easiest test to conceive is that an applicant, a homeowner, or a developer could build a project that complies with both. There's no way that he's in the situation that he is complying with one but violating the other. So they're clearly consistent with each other. The hillside management ordinance, by its own words, applies to all parcels in the city. And more importantly, it's your decision. The city council has the authority to interpret its own ordinances. In this case, only one interpretation of this ordinance is available because it says it applies to the entire city. That decision is yours. Finally, there's a point about the EIR itself, which, as you know, as we all know, having been through the last, I can't even count the years, has been through many iterations, many attempts to get this analysis right. Our letter from my law firm that we delivered on Friday indicates a long series of places where we believe the EIR is still insufficient. I want to talk about one in particular where we believe the EIR is clearly inadequate and more work is needed. In response to this back and forth, the EIR and the traffic consultant redid its traffic study, calculated some higher trip numbers to try better to capture the congestion problem in Carbon Canyon that you've heard so much about. Whether the traffic study itself achieved that, I leave to the traffic experts. I don't believe it did, but that's not my area of expertise. What it clearly did is show that there would be more traffic on Carbon Canyon Road than the previous studies indicate. But what it didn't do is take those higher traffic numbers and recalculate all of the other impacts that flow from traffic. Traffic numbers directly affect greenhouse gas emissions, directly affect air quality, directly affect hazards. The EIR looks at traffic again, finds more traffic, but doesn't go back and look at all of these other things. It's a clear place where there's new information that requires new analysis because this new information is more up to date and more correct. New analysis that requires this EIR to be redone. So, regardless of what you think about the merits of this project, although I can't see how anyone could see that presentation and think otherwise, regardless of what you think of the merits of this project, this EIR still needs work, and this is not the time to approve this project on the basis of an EIR whose own calculations don't match up and are not consistent internally. With that, I think I'm the last person to be delivering new material, and that's going to wrap up unless you have any questions on the legal issues.